In today's video, I'm going to talk about battery, felony battery, and aggravated battery crimes in Florida. My name's Adam Rossen. I'm a criminal and DUI defense attorney in South Florida. I'm a former prosecutor. We have over 400 five-star reviews between Google, Avo, and a few other websites. We help good people when bad things happen to them, and we're doing this video series to really educate people on different crimes and what the law is down here in South Florida. To prove the crime of battery, the state must prove the following two elements beyond and to the exclusion of every reasonable doubt. Now, the first element is that the defendant actually and intentionally touched or struck the victim. And the second element is that that touch or strike was against the victim's will. So for a misdemeanor battery, injury is not required at all. According to the law, you can walk up to somebody, flick them in the forehead, and that's a touch or a strike. If it's against that person's will, then that would satisfy those elements for a misdemeanor battery. Even though it seems pretty ridiculous, it still satisfies the elements. There's another crime called felony battery. So this is a felony. It's a third-degree felony, and in the next videos we'll discuss the penalties and everything there is to know about those crimes. But felony battery has three elements to that crime. Element one is the defendant actually and intentionally touched or struck the victim, just like misdemeanor battery. Number two is that touch or strike was against the victim's will, just like misdemeanor battery. But now we have a third element, and 3A is with one prior battery conviction, meaning if somebody had a prior misdemeanor battery conviction and then now if they were charged again, then that misdemeanor battery could be upgraded to felony battery. Or element 3B, which would be the defendant caused the victim great bodily harm, permanent disability, or permanent disfigurement. So great bodily harm, permanent disability, or permanent disfigurement. Now, in felony battery, no intent to cause the great bodily harm, the permanent disability, or permanent disfigurement is required. So those injuries can happen without the state needing to prove the intent in the defendant's mind. Great bodily harm is defined and distinguished from slight, trivial, minor, or moderate harm. It is not something as simple as mere bruising. Great bodily harm has to be serious. In fact, there's been case law from the higher courts that have said when there's been no testimony that the victim required medical treatment for burns or that that victim had any long-lasting ill effects or scars from the burns, then it could not be great bodily harm for felony battery or for the next crime, aggravated battery. So the courts have said that you can't just assume great bodily harm, permanent injury, or permanent disfigurement. There actually has to be testimony about that and evidence about that. And I'll go into all of those in more depth in some of the later videos. And the third battery crime that we have is called aggravated battery. And this is also a felony. And out of the three, this is the most serious. So the first element, just like the other two, defendant actually or intentionally touched or struck the victim. Element two, just like the other ones, that it was against that person's will. And element three is where we have the differences and the distinctions between the other two. So it's the same as felony battery, where there has to be great bodily harm, permanent disability, or permanent disfigurement, but that has to be intentionally or knowingly caused by the defendant. And if the prosecutors can prove that the defendant intended the great bodily harm, intended the permanent disability, intended the permanent disfigurement, then they can proceed with that charge. And that's the most serious of the three battery charges. Or if they prove that the defendant used a deadly weapon. And a deadly weapon is an object that is likely to cause death or great bodily harm if it's used as it's normally supposed to be, or as it can be anticipated that it would be used. So we used before an example in one of my other videos of a steak knife versus a butter knife. If you tried to attack somebody with a steak knife, everybody's going to consider that a deadly weapon. But what about a butter knife? You can argue that a butter knife is not deadly, but if you use the butter knife in a way to stab somebody maybe in the eyeballs, right, then it could be deadly. So those are little distinctions that good lawyers make, whether they're good prosecutors, good defense lawyers, and those are little things that we really fight about, and that's what the law says. So a weapon that is ordinarily not deadly, if used in a certain way, could be deadly. Let me give you a real-world example of some actions that could be a misdemeanor battery, a felony battery, or an aggravated battery. Now let's say I push somebody and they fall down. There's no injuries. I'd be charged with a misdemeanor. That'd be misdemeanor battery, right? Just through all the elements and everything that I said before. But let's say I push somebody to the ground and they break a bone. Well, I didn't intend for them to have that great bodily harm or to have that permanent injury with the bone break, but they did. That would be a felony battery. Now let's say, same set of facts, I push somebody down, but we're at the top of a staircase and I push them down the staircase knowing that I'm pushing them down the staircase and they break a bone, right? Then I would be charged with aggravated battery because the prosecutors would say that I had the intent to create the great bodily harm, the permanent disfigurement or permanent disability. So hopefully that example is a good way to illustrate the differences between misdemeanor, felony, and aggravated batteries. Now we're going to keep going with this series, but if you have any questions after watching this video, anything about battery, felony battery, aggravated battery, you can always give us a call, 754-206-6200. We love helping good people when bad things happen to them. We have free strategy sessions that are a lot different than other law firms. You come on in and we're going to go over everything about your case and develop the strategy from day one. So once again, if you have any issues, questions, concerns at all, feel free, give us a call, 754-206-6200, or you can find us at rossenlawfirm.com.